One of the areas of law that I focus my practice in is what people would generally call a slip and fall or a trip and fall. The legal term for it would be a premises liability case. The explanation for that really is if you were hurt on someone else's property, whether it be a business or a private person, and it be due to something they did wrong or something they didn't do that should have been, negligence or actions. So with premises liability cases, the hardest challenge we run into is that we oftentimes don't have the evidence we necessarily need. So a large part of getting an attorney involved in the case early on is the investigation stage. When a customer falls in a store as an adult, it embarrasses us. So what do a lot of people do? They jump up and try to deflect away from them as quickly as possible. And they may not get the evidence, whether it be a photograph or an incident report, because they're simply embarrassed. Now, if there is an incident report, we start looking at how can we establish and prove the case. A lot of people think, oh, well, if I fell on Walmart or H-E-B's property or a business's property, they're responsible. And unfortunately, that's not the case. In fact, I have to show that the store did something wrong or they didn't do something that they should have done. And so that's where, again, creativity comes into play so that I can look to identify why a company would be responsible for causing your fall. Sometimes there isn't. Accidents can happen. But many times what we find is that there is negligence that occurred and that the company should be held responsible for hurting our client.